You won't be able to hear what I'm talking right now. So, good evening, everyone. I'm Seth Lon, the faculty advisor to our moot court program, and on behalf of Dean Austin Parrish and the entire Bauer School of Law, it's my pleasure to welcome you to the final rounds of our 53rd annual Sherman Minton Moot Court competition. Our competition is named, as many of you know, for Justice Sherman Minton, a 1915 graduate of our school and Associate Justice of the United States Supreme Court. Justice Minton's portrait is hanging at the back of this room and smiling down on us tonight. Hanging on the wall just outside the moot court room is a plaque that has the names of all the past Sherman Minton Moot Court winners, and tonight, after the arguments, 2 more students' names will be added to that plaque as Sherman Minton champions. Now, the process it took to get here and the competition of this length stretching out over many months, and really the planning began last April, obviously couldn't happen without the work of many, many people. First and foremost, our spectacular student advocacy board, to whom you're going to be introduced in a few minutes, but also literally hundreds of other people, from the first year students who bailiffed to the other 108 students who participated in the competition, to the alumni judges, to many faculty members who judged, and the many members of the administration and staff of the law school. But also thanks to everyone here who supported the participants through this whole process, your classmates and family members and friends who stood by people and helped them when their spirits may have been down and showed up here tonight to cheer on the last 4 finalists. So thank you to all of you as well. I'm now going to turn the program over to the Chief Justice of this year's Advocacy Board, Zachary Miller. It's been a real pleasure to work with him. Zach has guided the work of this board and the creation of this competition since last April, as I said, and he's done a tremendous job. Thank you, Zach.
Thank you, Professor Lawn, and thanks to everybody here in attendance tonight for supporting this group of competitors that we have. The Moot Court competition is one of the largest student and alumni events hosted by this law school. We are very excited for the arguments that we have planned for tonight. This year's competition began in September, and it's been an incredible couple months preparing to get here. With all the work that goes into putting on such a large competition, I think it's safe to say that it wouldn't happen without the work of this year's executive board. It has been an honor to serve with such an incredible, talented, and hardworking group of individuals, and I would like to recognize them all individually today. Some board members are still outside doing work to make sure that tonight's round of arguments go smoothly, but if you are in the room, I would ask if you could please stand and be recognized when I say your name, and if the audience could please hold their applause until the end. Our executive judge coordinators were Carolyn Haney and Jennifer Smyth. Our executive competition coordinators were Bailey Onstead, Sarah Brown, and Taylor Fontan. Our executive problem editors were Anurima Deshpande, Sarah Lodi, and Cody Vaughn. Our executive advocacy coordinator was Alexa Urbanic, and our competition board coordinator was Ashley Moore. Thank you all so much for all the work that you've put in this year. Along with the work of this year's executive board, we could not have put on this competition without the help of our very own competition board. Since the beginning of the summer, the competition board has been drafting memos to help us prepare to create the unique problem that we gave to this year's competitors. They've been grading briefs, judging practice arguments, and continuing to judge throughout the competitive rounds. So at this time, if all the members of the competition board in attendance could please stand and be recognized for all the hard work that they've done this semester. I would also like to acknowledge a particular faculty member, Professor Seth Lawn, who you just heard from. Professor Lawn is the faculty advisor for the Moot Court competition and has dedicated his time this semester to teaching this year's group of competitors appellate advocacy, as well as ensuring that the competition goes well at every turn. I think it would be hard to find another faculty member at another law school who cares as much about the student Moot Court experience as Professor Lawn. And it has been a privilege to work with him this semester. So thank you so much, Professor Lawn. But tonight truly is about celebrating the hard work and accomplishments of this year's competitors. We've heard some incredible arguments over the past few months, and I hope the competitors in the room have been able to have some fun along the way. So with that, I will turn it over to Sarah Brown and Taylor Fontan, who will acknowledge some of this year's competitors. Thank you all so much.
Thank you again so much for coming tonight. This truly is a culmination of so much hard work on behalf of so many students, and we really appreciate you coming here. And now, as Zach noted, this competition really all began back in September. All the students, all the competitors were required to write a brief, an appellate brief with a partner. Now, once they completed the brief writing stage, they completed 2 oral arguments. One was on brief on the side that they had written their brief on, and they also had to argue off brief. Then after all of those scores were tabulated, we came up with the top 32 petitioners and the top 32 respondents. And then we went into the tournament rounds. At that point, all of the competitors went head to head, and the panel of judges would decide which competitor moved forward. So tonight, we'd really like to acknowledge and really congratulate all of the competitors, and specifically the top 32, the top 16 competitors, and the top 8 competitors.
Starting with our octa finalists, Alex Alpert. Please stand when your name is called. And please hold all applause until we've called all the names. Thank you. Stephen Bassett, Kendall Bullockman, Brittany Croft Swassemer, Robert Dupler, Jason Fairstein, Zoe Jempo, Blake Hatfield, Devin Heyman, Elena Lentz, Macy Passavinto, David Saylor, James Seaver, Purva Sethi, Thibaut Vildent, and Christopher Wilkes.
Okay. Now, go ahead. Applause for the 32. Okay, now I have the pleasure of announcing the quarterfinalists from this year's competition. Betsy Astrup, Connor Christie, Mary Rachel Durso, Robert Esrock, Carolyn Griffith, Allison Hilmer, Christian Townsend, and Grayson Wells.
And finally, we have the pleasure of introducing you to our semifinalists, Samantha Carson, Allison Pulliam, Krista Cumming, and Amanda Vaughn. Give them a hand. Thank you all for your hard work over the past few months. It's been incredible to watch you all argue and just give your all. As you may know, the Sherman Minton Moot Court competition is centered around an original, unique problem that is written by the Moot Court problem writing team. And we'd like to now hand it off to Anurima Deshpande, a member of that writing team, to introduce you to this year's problem. Thank you.
Thank you. On behalf of this year's Moot Court Board, I'm very proud to present to you this year's problem, United States versus Menon. 2 weeks ago, the 14th Circuit Court of Appeals denied the defendant Pete Menon's appeal. We hope that the Arcadia News broadcast from that day will provide you with enough context to fully enjoy tonight's arguments.
Hello, and welcome to Arcadia News and Live. I'm Alex Sawyer. And this evening, we're covering a topic that's been buzzing about the community in Arcadia for 2 years: the terrorist attack and bombing of the Arcadia multi-use development site that set back the construction timeframe for almost a year. Now, this case has been anything but staggering. Scientific environmentalism, you folks at home, a local group, or some would say a cult, was found to be responsible for the bombing when the 2 suspects caught on camera were wearing scientific environmentalism t-shirts. Pete Menon, a high-ranking member of scientific environmentalism, was one of the suspects. The other suspect, another member of scientific environmentalism, was Becky. She's still at large. She was last seen in a gas station in Southern California 2 years ago. So, why did scientific environmentalism get involved in the way it did with multi-use development?
Okay. Well, first of all, I need to say that scientific environmentalism in no way sanctions or condones the actions of Pete Menon and Finalists.
Oh, so you didn't know about scientific environmentalism's opposition to this bill?
Of course, scientific environmentalism is opposed to this bill. One of the core principles of scientific environmentalism is we oppose any kind of commercial development that's infringing upon historic properties and buildings in the city. But we oppose things in different ways than Pete and Karina did.
5 months ago, Pete Menon was convicted by a jury of his peers, you guys, after the government presented evidence, along with other testimony, that Pete had access to the phone that likely caused the bomb detonation, and had both a mask and a shirt in his bedroom that matched the ones used during the commission of the crime. The cell phone found at the crime scene, however, was locked. And when asked to produce the passcode, Mr. Menon refused, just like I refused when my wife asked to get my cell phone. After trial, new evidence came to light that Menon could have been framed. A picture, a note, and an email chain tended to show that Menon was not the culprit. After challenging the prosecutor's failure to disclose this evidence on a motion after trial, the court upheld Menon's conviction. Today, defendant Pete Menon's conviction was again upheld by the en banc 14th Circuit. We have a reporter at the courthouse live to speak with Mr. Menon and his appellate counsel. How's it going out there, Ashley?
Hi, thank you, Alex. Once again, my name is Elena. We've worked together for 5 years, and you should know that. I'm here outside the 14th Circuit Court of Appeals, where the entire court just ruled that Pete Menon's convictions will be upheld. Mr. Menon, how do you feel about this?
I am baffled. I didn't do this. I'm innocent. And I would never protest commercial development with files. I am terrified of explosives, and someone could have gotten hurt. The government has it out for me, and my rights were violated.
Mr. Tillman, you represented Mr. Menon throughout this entire process. Your thoughts on the court's opinion today?
I am just as bad as my point. The government did not have a solid case at trial, and with the suppression of evidence and the government's violation of my client's Fifth Amendment rights, I can assure you we will be petitioning this all the way to the Supreme Court for certiorari.
Mr. Tillman, you mentioned something about your client's Fifth Amendment rights. Could you elaborate on that?
So during trial, the government showed a video to jury of my client invoking his Fifth Amendment privilege against self-incrimination in response to questioning about the passcode to a communal scientific environmentalism. So that is a complete violation of Supreme Court precedent.
Well, you heard it here first, Alex. We may have a Supreme Court ruling to be covering later. Once again, my name is Elena.
Thank you, Ashley. My boy, Assistant U.S. Attorney Finch, who represented the government in front of the 14th Circuit. Mr. Finch, what's your take on Mr. Zellner's case?
No offense to Mr. Zellner, but unfortunately, his characterization of these issues is entirely incorrect. While it may be true the government failed to turn over some evidence, the fact is we had no obligation to turn over that evidence in the first place. Since both the defense and the government have agreed that this evidence wouldn't have been admitted at the trial anyway, there's no way it can have an effect on the trial.
All right. I'm buying it a little bit, but what about this Fifth Amendment stuff, Mr. Finch? Like, Zellner seemed pretty concerned with it.
That's a complete non-issue, Alex. The Fifth Amendment protections do not extend to the protection of passcodes, so we didn't violate Mr. Menon's Fifth Amendment rights.
Well, guess we're going to wait patiently after hearing from these folks to see if the United States Supreme Court grants cert for these issues. If they do, then you're going to hear it first here on Arcadia News. That's all we have tonight, though, on a firm between us and Arcadia News at 5. Thank you on behalf of Arcadia News to all of our guests.
Following that decision, the United States Supreme Court granted a hearing in Mr. Menon's case. The court was asked to decide two questions. First, whether evidence that is suppressed and exculpatory can ever be material for Brady purposes when it was inadmissible at trial. And second, whether an individual has the right under the Fifth Amendment self-incrimination clause to refuse to divulge their passcode when asked to do so by the police. The Supreme Court will hear argument on the matter today. We've heard some incredible arguments in this competition so far, and we're certain that tonight will be no different. We hope you enjoy yourselves.
All right, so very briefly before we get started, I just wanted to remind everyone that we are about to go into court. So if everyone could please turn their cell phones off now and remain quiet and seated until the end of the arguments. Thank you.
All rise. The Honorable, the Chief Justice and the Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court.
Thank you. Please be seated. Now call the case of Pete Minton, petitioner versus United States of America respondent. Counsel, can I ask you to introduce yourselves, please? Thank you. Is the petitioner ready to proceed? Go ahead.
Mr. Chief Justice, and may it please the court. My name is Nicholas Bauer, and I represent the petitioner, Mr. Pete Minton. This case is about the constitutional due process rights of the accused to a fair trial in the criminal proceeding. Under this court's decision in Brady v. Maryland, the prosecution has an obligation to turn over exculpatory material evidence to the accused. The question before us this evening is how inadmissible evidence should be treated under the materiality prong. The circuits are split into three tests on how to handle inadmissible evidence and the prosecutor's duty. First, there is the general question test, which has a court ask, would the evidence have an impact on the outcome of the trial? Second, there's the non per se rule that says that if inadmissible evidence can point to admissible evidence, it is material.
Counsel, can you explain to me the difference or any daylight that you see between the non per se rule and the Fifth Circuit's approach?
Yes, Your Honor. The Fifth Circuit approach in Felder v. Johnson asks that the court look at a general question, which is, would the evidence in general have affected the outcome of the trial? Would there be a reasonable probability of a different outcome? Under the non per se rule, the court looks for the admissible evidence to point to specific admissible evidence in order to be material. So Mr. Minton asked that this court adopt the Fifth Circuit's rule in Felder v. Johnson, the general question standard, which allows for the court to ask a general question as to whether the disclosure of the evidence would have created a reasonable probability that the result of the proceeding would have been different.
Mr. Bauer, can you just go through what concrete evidence you think you would have been able to come to on Mr. Minton's behalf if you had seen this evidence before trial?
Yes, Your Honor. If Mr. Minton had seen this evidence before trial, he would have had an opportunity to present a different approach to his case, his theory of his case. He would have been able to show that he was framed. The record that we have before us has evidence that Mr. Minton's prints were on the cell phone and that there was access to the rooms at the SC compound by multiple members of SC. In fact, three were in common, Mr. Minton, Mr. Canfield, and Ms. Kite. So using that plus the email chain, which stated that the email chain said in code, using a code name, black eyes may still be useful to us, even if he doesn't know it. Mr. Minton did not have this theory available to him. Simply having evidence in his room at the SC compound did not suggest that he was being framed. It suggested that somebody else had discarded some items in his room. He had no reason to suspect that he was being framed. So having the opportunity to view that information and
if we apply your reasonable probability standard, how do we give any guidance to the lower courts on how they apply that? With the admissibility standard, at least there's clear rules and guidance instructing them how to make that determination. So if we adopt your Fifth Circuit, what guidance do you have that we can give on how you determine reasonable probability, which seems pretty nebulous.
Yes, Your Honor. In this court's decision in Kyles v. Whitley in 1995, this court said that a reasonable probability of a different result is accordingly shown when the government's evidentiary suppression undermines confidence in the outcome of the trial. So it's about determining if there's confidence in the verdict.
But if that's true, how do you undermine an outcome if the evidence isn't admissible? By definition, presumably you would not be undermining an outcome if the information would never be before the jury to begin with.
Yes, Your Honor. So even though it's inadmissible, the evidence still has evidentiary value. It still has probative value because the federal rules of evidence, 104A, which are created by this court, allow a judge to consider inadmissible evidence in determining whether or not other evidence would be admissible. So if inadmissible evidence is not turned over to the defense, as in Mr. Minton's case, it's also evident that the court was not given that evidence. So in this case, in Mr. Minton's case, the court did not have this email chain, these photographs showing other individuals at the scene of the crime, and a letter that, handwritten letter that specifically stated Mr. Minton was innocent when it made other rulings. Now, the record that we have before us in this trial does not indicate other evidentiary rulings that were made. Those parts have been omitted, but it is within the judge's realm to use that inadmissible evidence in deciding on other evidentiary rulings that may have had an impact on the outcome of this trial.
Mr. Bauer, two questions for you. Aren't we reviewing the rulings of the trial judge on an abuse of discretion standard? Would you agree with that?
Yes, Your Honor.
Well, based on the abuse of discretion standard, didn't the trial judge act well within her discretion to determine that this inadmissible evidence, whether it could have led to something else, was mere conjecture? Wasn't she acting within the bounds of her authority, within her discretion to do so?
No, Your Honor. If we turn to Wood v. Bartholomew, this court decided in 1995, it does say that the defense cannot have what they deemed mere speculation in trying to determine if evidence would have affected the outcome of the trial. In Wood, the defense had polygraph results that potentially showed some discrepancies in the responses of two witnesses, who are actually the sister and the brother of the accused. But even once the defendant and the defense counsel had those polygraph results in hand, they did not have a different line of questioning or a different theory of the case to pursue. If Mr. Minton had had this evidence available, he would have had the opportunity to pursue a different theory of his case. Additionally, Kyles v. Whitley brings in the concept of the thoroughness of the investigation. And Detective Vasquez did not follow up on the leads. In fact, Detective Vasquez said that in his opinion, the email chain could have been completely fake and didn't seem credible. As Kyles said, it's the criminal trial, as distinct from the prosecutor's private deliberations, that are where the chosen forum for ascertaining the truth in criminal accusations. It was completely inappropriate for the police, Officer Sidor with the letter and the photograph, who deemed them both a hoax in his testimony on page 49 of the record. They simply usurped the power of the court by determining materiality on their own.
The more the information is less relevant, right? The more that it's truly not material at all, that's always going to be the case, right? Like if I have a red herring, somebody calls and says, an anonymous message leaves a tip and says, I was told by somebody else that they told me he didn't do it. So completely not relevant, not admissible. That's another instance where the police wouldn't investigate, right? Because it has no materiality. It's not admissible. It's not relevant. It's completely anonymous. So in all those circumstances too, you would have the same argument, right?
Well, Your Honor, there is the threat under a general question standard that you could incentivize the accused or associates of the accused to potentially falsify evidence in an attempt to mislead the police. But at the same time, by accepting a rule such as the per se standard, you're unfairly punishing the defendant for not obtaining evidence that they had no reason to believe existed. And that language comes from the Seventh Circuit in Boston.
So what do you do in my hypo then? You get an anonymous tip from anonymous that says, and all the tip is, I heard from somebody else that they told me that the person didn't do it. Does that have to be disclosed?
Your Honor, the detectives or the police should at least follow up on that. That's what the defense would ask in a case like that, is that they follow up and use their best judgment In this case, Detective Vasquez and Officer Saito did not follow up properly. They did not go to the coffee shop and look for logs of the computers. They did not attempt to.
So are you saying that Brady has an affirmative obligation to compel police to do additional investigation as well as disclosure?
No, Your Honor, but there is a room in this court's decision in Kyle's to consider the thoroughness of an investigation and to, it's not about the bad faith or the good faith of the investigators or the prosecutor. It's about the thoroughness. It's about disclosing favorable evidence. And it's about the fact that the courts should be where the admissibility of evidence is adjudicated.
You'd be happy if you just knew about the evidence and you could follow up on it. You're not necessarily asking the police officers to follow up on it, right?
Yes, Your Honor, that's correct. If Mr. Minton had this evidence at the time that the police received it, he would have had an opportunity to either himself or through his counsel or an investigator follow up on those leads as well.
So does that mean that the real obligation, as you see it, is for the prosecution to disclose everything? And even if they don't have an obligation to do the investigation themselves because follow-up would appear to be fruitless, they should still turn it over because who knows what the defense might be able to do with it?
No, Your Honor, we're not advocating for an open file policy. I mean, if we look at this court's decision, Strickler v. Green, even when there was an open file policy, the outcome was that there was not a reasonable probability of a different outcome when they did not have these notes that were written from a witness who appeared to not remember a lot of her statements prior to the trial. So even though the Commonwealth of Virginia has an open file policy, it didn't make a difference in that case. We're not advocating for that. We're advocating for a standard like the Fifth Circuit has in Felder v. Johnson that allows the courts to look at the general question of whether the evidence would have affected the outcome of the trial. Now, in contrast to a per se rule, per se has the problem of incentivizing the police to not fully investigate. It also unfairly punishes a defendant because evidence that they didn't know existed is deemed inadmissible or immaterial.
Mr. Bauer, let me ask you this. I understand all the what ifs that you're suggesting. What about this? What about that? But as an appellate court, aren't we required to rule on the record that's before us and not on the what ifs? Correct me if I'm wrong. If I misspeak, I want you to tell me that. But the record that we're looking at, none of this stuff turned out or panned out. The argument you're saying is, well, what about this and what about that? And it's all conjecture because none of it is in the record. Am I not accurate in saying that?
That is accurate, Your Honor, although Mr. Minton has not had the opportunity to fully investigate that information. He has not had the opportunity to pursue the theory that he's being framed. And quite simply, this inadmissible evidence should be treated as under a general question standard from the Fifth Circuit to look if there's a reasonable probability that the result of the proceeding would have been different. Mr. Minton asked that you adopt this standard from the Fifth Circuit. And if there are no further questions, I thank you.
Thank you, Mr. Bauer. We'll hear from you again on rebuttal.
Yes, that's correct, sir.
We'll now hear from the respondent, United States, and representing the United States on this issue will be Mr. Appel. Mr. Appel, excuse me. Go ahead.
Honorable Chief Justice, Associate Justices, and may it please the court. Could have, would have, should have. In his argument, Counselor Petitioner used those words more than 10 times because this case is solely based on speculation. And that is not the standard this court has adopted when reviewing Brady claims for materiality, and it is not the standard they should adopt. First, I will address the per se materiality standard.
Mr. Appel, are you going to concede the per se standard?
I will not concede it. We understand and are sympathetic to the fact that the middle of the road standard, the one adopted by the 11th Circuit, is a better way to promote both deference to the defendant and to the prosecution, but I'm not willing to concede the per se standard, Your Honor. Should this court choose to adopt that standard, we would very clearly win because these pieces of evidence have been stipulated to being inadmissible.
You would concede that standard appears to be losing favor or losing steam among the circuits, would you not?
Yes, Your Honor.
And so assuming for a moment that we would adopt a non per se standard, or the standard that your adversaries would ask us to adopt, go ahead and present your argument from that standpoint.
So the standard that we would like you to adopt is the standard adopted by the Seventh Circuit in Wright v. Hopper, the idea that inadmissible evidence must be shown to lead to admissible evidence. In the lower court's opinion, in the concurring opinion, they listed three reasonable factors that puts the burden of proof on the defendant, and it is a very easy burden to meet if this evidence is material. The three factors are: the defendant must point to concrete evidence that could have been discovered, admitted, and would have changed the outcome of the proceeding beyond a preponderance of the evidence. That is a workable standard that not only allows defendants the appropriate amount of relief and deference, it also incentivizes prosecutors to encourage their investigators to follow up on inadmissible leads, which is what happened in this case.
Apply that standard. Why don't you lose on the facts? Doesn't the AUSA receive a tip along with the photographs showing somebody else did the crime?
They received a tip and they followed up on that tip and determined it was a red herring. There was no admissible evidence that came from it.
But once you get to that, right, isn't it potentially exculpatory? So isn't that exactly what petitioners are arguing, that at least they should then be able to investigate to determine whether they reach the same conclusion, right?
So it is potentially exculpatory, Your Honor. However, it is not material, and that's what we're debating in this case. And in order for the materiality standard that we're advocating for, the inadmissible evidence must be shown to have led to admissible evidence, which is not what happened here.
Is there room in your analysis to account for the degree to which the evidence would be considered exculpatory? So in other words, there's some evidence that might tend to suggest that another person was involved. And then there's evidence that suggests the person who's on trial is framed and wasn't involved at all. Both things might be material, but certainly if there's evidence that somebody is framed, that would seem to open the door to a potential miscarriage of justice at a very big level. To what degree does your framework allow a judge to take into account, the admissibility is not clear, it's not clear, but it would lead to admissible evidence, but the risk of a miscarriage of justice is such that the defense should have had a shot to try to develop an argument?
Well, Your Honor, we have to draw the line somewhere. We cannot have an open file, an open dump. Prosecutors, as part of their job and part of their duty as officers of the court, have prosecutorial discretion. So this standard allows prosecutors to have their discretion to follow up on their leads. The prosecutors, the United States, are not villains in this instance. They're not trying to put away innocent men and women. They're trying to ensure that justice is done. And while we do want to prevent miscarriages of justice, we also want to prevent guilty men from walking away. So what we need to do is find a middle ground, and we need to fit this into the context of the Kiles v. Whitley decision and the Strickler v. Green decision. Applying this standard from the 11th Circuit Court and the majority of other states and other circuits would allow the judge to weigh the outcome that this inadmissible evidence, which led to admissible evidence, could have had on the proceeding and on the verdict.
Mr. Appel, let me ask you this and follow up to my colleague's question. As the prosecutor, it's your job to convict, but to convict the right person and not the wrong person. And in light of that observation, isn't it the better thing, the better practice, particularly under the Brady decision, our Brady decision, to disclose exculpatory information? Isn't that more consistent with the spirit of Brady?
It is somewhat consistent with the spirit of Brady, but not with the spirit of the prosecutor's role in our justice system. This court has previously said in the U.S. v. Aggers decision, the prosecutor's duty is to prosecute with earnestness and vigor. Prosecutors do have a job to convict the right guy, but they also need to make sure that they can get a conviction and that we don't have guilty men guilty of terrorism, like Pete Menon, walking around in our society, potentially endangering others.
How does that have any? I'm just confused on why that is relevant to the Brady here. Here you've got a picture that somebody else did it. That's not only exculpatory. I don't understand why that's not material to whether this was the particular defendant or not. In those situations, even given everything you just said, why isn't that something that's disclosed under Brady? I guess I'm struggling with the argument that evidence that comes in, even if not admissible, that shows that somebody else did the crime isn't by definition material under the Brady standard.
Well, I understand your point, Your Honor. I'd urge you to consider the fact that this evidence doesn't show that someone else did the crime. It's a handwritten note describing the composition of a bomb that could have been sent by one of Menon's accomplices. And it's a photograph that, after undergoing technical analysis, we were unable to conclusively determine whether or not it had been doctored. It's a photograph taken.
But that's your analysis. And
Yes.
under any approach that you'd have us take, the decision as to whether or not to turn over this exculpatory evidence is left with the state. And the constitutional right that we're worrying about protecting is the right of Mr. Menon and the accused in a criminal case. Under any of these approaches, leaving that decision to the state, isn't it likely to lead, likely to lead to the discovery of exculpatory evidence? Doesn't this allow the prosecutor to determine the scope of the defendant's case?
It does not allow the prosecutor to determine the scope of the defendant's case. What it will do, especially if we adopt this relatively easy burden of proof, the three-factor standard, it will incentivize prosecutors and officers to follow through on their investigation and follow through thoroughly, which is what was done in this case. They conducted their analysis, they dusted for fingerprints, they followed up on the email chain as well, using personal knowledge of the site it was sent from. The officer had been there over 100 times. If the officer had been there in 100 visits and noticed security cameras or a log using the computers, then she would have followed up even further on it. But there has to be a line somewhere. We can't put a more onerous burden on officers. We can't allow the defense to dictate how far officers need to follow through on their investigations. What this rule would allow, it would incentivize prosecutors to discuss with the officers investigating to make sure that they follow through. If they can't find admissible evidence, then it does not need to be disclosed.
But aren't you suggesting that the prosecutor is going to make the sole determination as to what's admissible and what's not admissible? Isn't that what you're suggesting to us, rather than a judge?
So the prosecutor is not going to make the sole determination, but they're weighing it amongst the other factors of Brady. It's when it's exculpatory but not material, the prosecutor would be making that decision. However, we have a very wide range of evidence rules. Inadmissible evidence is allowed in for impeachment, and impeachment can be part of Brady claims. There's a very narrow window of inadmissible evidence in here, in this specific circumstance, where the prosecutor would be making those decisions.
But you agree with me that defense lawyers and prosecutors often see it differently as what's admissible and what's inadmissible. You agree with that, right?
Yes, I do, Your Honor.
And in what you're suggesting, though, is the prosecutor should have the final say-so and determine that certain exculpatory material might be inadmissible and therefore it's not to be disclosed. Is that what you're arguing?
Yes, Your Honor, in these limited circumstances, because we have to remember that prosecutors are officers of the court. This is not a civil case where you have two sides fighting out with each other. Their job, their duty is to promote justice. They're not going to bury these leads. We trust them. We give them discussion. We give them discretion. They're not going to bury a bunch of leads to convict the wrong men. Their goal is the same as everyone else's, that justice is done.
Don't we have to worry about the prosecutor that doesn't live up to those standards? I mean, the rule that we have to come up with in this case has to address people across the spectrum, even prosecutors that might be happy not to have to follow up on exculpatory evidence. I mean, what's your response to that?
So my response to that is that there's a relatively easy burden of proof for the defense to meet when they're filing a Brady claim. This court has recognized the serious danger of granting habeas relief or granting relief based on materiality that is merely speculative. We have to draw the line somewhere. There are worries that we will have prosecutors who are bad actors, but it has never been the position of this court or this country that we don't trust our prosecutors. There are methods in place, safeguards against prosecutorial misconduct. There are other suits that could be filed for that. What we need to do, the prosecutors are already fighting an uphill battle. They have the standard of, they have to
Let's assume we agree on that, and we take Justice Martin's earlier point that has nothing to do with whether the prosecutor's investigated or not, but whether the defendant is entitled to some sort of investigation. Isn't your standard requiring us to allow the AUSA to make a weight determination rather than a materiality determination? It seems to me in our earlier decisions, we would determine whether there was material to the actual case, the innocence or guilt, but not a question of weight. And what I'm hearing you argue is that the prosecutor gets to make a weight determination based on the police's own investigation, and that then can trump the materiality aspect if the prosecutor believes that the weight of the evidence is not that strong. Why should we turn our jurisprudence all to that rather than a more simple thing that adopt your standard, as you say, but say in this case it's clearly material because it goes to the innocence and guilt of who actually committed the crime, and therefore it has to be turned over, not because we want to incentivize or de-incentivize, but because we want the defendant an opportunity to investigate themselves.
Well, we do need to weigh, we have to engage in some sort of weighing of the evidence, because there's nothing preventing defendants or accomplices of their defendants from submitting inadmissible evidence, like very well may have happened in this case, to try to undermine the verdict, there's nothing here. Should we adopt this rule? What we're trying to do is avoid someone coming in at the 11th hour, a guilty man or woman coming in at the 11th hour with some last-ditch effort with made-up evidence that sends the police on a wild goose chase and being able to use Brady to get out of paying for the crime that they committed. Additionally,
But wouldn't the effect actually be if the obligation is to turn it over rather than to run out the full investigation? Doesn't that put the burden on the defense then to spin their wheels following up on evidence that might not lead anywhere? It seems to me that if it's a disclosure requirement and your concern is the impact it's going to have on the prosecution and the police officers, perhaps disclosure is the answer, because now the defense will be the ones potentially spending time doing something that's not worthwhile.
we also want to avoid that, especially in cases involving public defenders who are significantly overworked. We don't want the defense attorneys spinning their wheels when they have fewer resources, arguably, than the U.S. government does. However, I think under the broader standard adopted by the Fifth Circuit as well, the facts of this case would still allow the government to win. There is no reasonable probability demonstrated by the petitioner that confidence was undermined in the verdict. So should this court choose to adopt this broader standard, we ask respectfully that you still find Mr. Menon guilty. Your Honors, the idea that defense could have pursued a different strategy at trial is simply not accurate. They had evidence of multiple people having keys to the rooms.
There was a fingerprint on the photograph that tied it back to the organization. Would this then have been, under your standard, whichever one you apply, would it then have been required to be turned over?
Yes, Your Honor, because it would be borderline admissible evidence. That would be significantly greater than a photograph that may have been doctored that we don't even know came from the scene. Fingerprints point to actual DNA evidence. If it led to someone at the compound, it would have at least pushed the police to follow up on a further investigation of that compound.
Yeah, I'm concerned because you said borderline admissible, and isn't part of the problem with using admissibility as a touchstone the fact that you don't know at the time that you're investigating what's going to be admissible or not? There might be rulings during the pretrial process or even during the trial where things that you didn't realize were going to be considered admissible are or could have been. Why isn't the Fifth Circuit approach better? Because it takes that legal determination or the type of determination a judge may be making during a trial out of the picture and just focuses on really the interest of justice.
The Fifth Circuit approach also allows for a large degree of speculation, which is something we're trying to avoid. In Wood v. Bartholomew, this court said it cannot be based on mere speculation. However, Your Honor, under the Fifth Circuit approach, Mr. Menon is still guilty, and I would like to, if this court should choose to adopt that standard, I'd like to discuss that briefly. Mr. Menon, they had the opportunity to pursue a different strategy. They knew that if Mr. Menon didn't commit it, those clothes were put in his room. They knew about the keys. This email chain, this inadmissible email chain would not have led them to pursue the theory that he was framed. The defense made a strategic decision not to pursue that, similar to the defense in Wood v. Bartholomew. We do not grant relief for Brady based on the defense deciding to adopt a different strategic decision. We cannot allow force prosecutors to consider defensive strategy.
You do agree that if there was a fingerprint, that would be enough because there would be a connection even under that theory?
I know, to follow down that hypothetical, Your Honor, that would have at least pushed the police to conduct a further investigation.
Why not?
Whatever came from that investigation would be enough.
So that makes sense. But then here, if I understand correctly, the note provided details of the bombing that had not been disclosed to the public. Why isn't that a sufficient enough fact to create the connection? So if your argument is that if there was a connection like a fingerprint, that would change the balance, why isn't the fact here that there's information in the note that nobody else knows about, why isn't that a sufficient connection under the legal standards you want to apply?
See, my time has expired.
You may answer the question.
Thank you. Your Honor, it's not sufficient because it's entirely possible and it would allow a broad range of accomplices of defendants to send. It's very well, Menon had an accomplice who is currently in hiding. That person very clearly could have known the composition of the bomb and sent that letter in, and we cannot allow something like that to be brought in, result in relief under a Brady claim, and then have a guilty man walking among the rest of us innocent out in society. For the reasons we've explained previously, if there are no further questions, we ask that you uphold the ruling of the lower court.
Mr. Appel.
Thank you.
Mr. Bauer, rebuttal.
Thank you, Your Honor. Society wins not only when the guilty are convicted, but when criminal trials are fair. Our system of the administration of justice suffers when any accused is treated unfairly. These are the words of this court in Brady v. Maryland. The government has suggested that they are most concerned about guilty people going free. We are most concerned about, Mr. Minton is most concerned about the rights of the accused, the constitutional right to a fair trial. That is the spirit of Brady. The spirit of Brady is about a fair trial. As this court said in Bagley, they do not want a miscarriage of justice to occur. This is the moral hazard of Brady. When the prosecution suppresses evidence, the penalty for the accused is that they might spend a number of years, maybe the rest of their life in prison, and never know that their rights were violated. If the prosecution is caught on suppressing favorable material evidence, they simply have to redo the trial. That is a great disparity in the punishment that the accused and the prosecution face when a Brady violation is allowed to occur. By adopting the general question standard from Felder, this court will give lower courts the ability to review in general if the evidence would have affected the outcome of the trial. Now,
Mr. Bauer, I'm concerned that whatever test we adopt, you still have a tough row to hoe with respect to the admissibility and inadmissibility of the evidence. And couldn't it fairly be said that Bartholomew is just reasoning the alternative? That is, after finding the polygraphs not material on the basis of inadmissibility, wasn't the court just explaining why admissibility is a good ground for materiality rather than actually ruling on a ground other than admissibility?
Your Honor, in Wood v. Bartholomew, this court found that, yes, mere speculation was not enough. And they did determine that the polygraph evidence did not make a difference in the outcome of the case. And they determined that it did not allow the defense to pursue a different theory or a different line of questioning. Mr. Minton would have had the opportunity to show that he was framed. Simply finding items in his room at the compound did not suggest he was being framed. He was friends with these individuals. He did not suspect that they were out to get him. So Mr. Minton asked that this court adopt the rule from the Fifth Circuit in Felder v. Johnson and apply the general question standard in determining if inadmissible evidence would have an impact on the ultimate outcome of a trial. If there are no further questions, I thank you for your time.
All right. Thank you, Mr. Bauer. We'll now hear argument as to our second issue, and arguing on behalf of Mr. Minton is Mr. Adams. Counsel, you may proceed whenever you're ready.
Mr. Chief Justice, and may it please the court. In this case, the district court fined and jailed Mr. Minton for invoking his Fifth Amendment rights and then displayed evidence of his invocation to the jury at trial. This court evaluates communications for Fifth Amendment privilege by placing them in one of three buckets. First, purely testimonial communications. Second, non-testimonial communications. And third, acts of production with testimonial characteristics to which the foregone conclusion doctrine applies. Here, Mr. Minton's disclosure of a passcode would be a purely testimonial communication because it relates the factual assertion that he has control over a device found at the scene of a crime. On these facts, this court has the opportunity to make a narrow holding and craft a rule that will be easily administrable by lower courts going forward. And under such a rule, Mr. Minton's conviction must be vacated. First, the district court erred when it decided as a matter of law that this was an act of production rather than a purely testimonial act. To begin with, the Fifth Amendment covers any communication that is testimonial.
Oh, wait a minute, Mr. Adams. Isn't producing the passcodes like reproducing a handwriting sample? they require some mental capacity, but disclose no factual information by themselves. Isn't that a step too far to treat them as testimonial?
Well, Your Honor, certainly there are cases in which we have to evaluate passcodes as a question of whether they contain certain testimonial information in and of themselves. For example, many people use their birthdays as a passcode for their devices. And so that would obviously represent some sort of testimonial communication. But the point on these facts is that unlike many of the device cases that we've seen in the lower courts in recent years, as this
People use a fingerprint.
That's certainly true, Your Honor. And what this court has found in relation to fingerprints and in relation to displaying other physical characteristics is that those things are non-testimonial communications. Those would go in the second bucket. Those cases.
Mr. Menon had admitted that it was his phone, so he conceded it. Would that mean that you would lose this case?
Your Honor, I don't believe that there would be any necessity of finding that Mr. Menon was guilty simply because he had control over the phone, because it is found in the record here that there are many people who have control over this phone. And
I'm sorry, I thought you were drawing a distinction between control type cases and non-control cases. If he had conceded that it was his phone, is it still testimonial or production then, or is it then totally fine to have him reveal the passcode?
Well, Your Honor, the point of the testimony in this case is that whether or not it would prove that fact beyond a reasonable doubt, following this court's decision in Castigar, it is what the accused reasonably believes will be done with the evidence at hand. And if Mr. Menon reasonably believed that this evidence was incriminating and could be used against him at a criminal trial, that is what matters for the purposes of establishing whether this was a testimonial communication. And many cases have followed along from that. Now, we are not asserting that there is any particular difference between finding his control over the passcode and finding his fingerprints on the phone, for example, other than the fact that it asserts his ability to open the device and control the contents of the device, which the fingerprints do not do. So it does have a slight difference.
I'm sorry. Mr. Adams, let me ask you, cover a similar point from a different perspective. When I was in law school, to the extent criminals kept records and documents, they kept them on paper. We didn't have cell phones. Nowadays, if I understand your argument, your client shouldn't have to turn over his passcode and you want the Supreme Court to issue such a ruling. Well, then theoretically, wouldn't it be possible for criminals to put all documents and records in electronic format on cell phones, put a passcode on it, and even though the standards to get a search warrant for law enforcement haven't changed, if law enforcement meets those standards, they get a search warrant, they're going to be stopped by technology from getting the same kind of records and documents that they could get in paper format. Now they can't get them in electronic format. Isn't that what you're asking us to do?
Well, again, Your Honor, we are not looking for a standard that would apply to all cases in which there is a passcode to a device. That is the distinction in this case, is that the control of the device is an issue in here. Whereas in many of these other device cases that we've seen in recent years, these devices were seized from the person or were seized in a search warrant from the person's premises, and the control of the device is the very thing that the government asserts is a foregone conclusion in those instances.
So is your position that the fingerprint cases are decided wrongly in the control cases?
For example, State v. Stahl is the Florida case. Is that what you're referring to?
In any cases, if you're making a distinction between control cases and cases where you're getting access to documents within it, presumably you have to believe the fingerprint cases are wrong in the wrongly decided in the control cases, because under your theory, the acknowledgement of the fingerprint on the phone would reveal that there was control of the phone, right?
In the instance where the device was not seized from the person, that would certainly be the case. Again, the question is from where this device was taken. If the device here was found at the scene of the crime, and if I may pose a simple hypothetical to the court, imagine, if we will, that we found a gun at the scene of a crime. It has the accused's fingerprints on the gun. It has his monogram on the handle, and the gun is presented to the accused in an interrogation, and he is asked, "Is this your gun?" Now, we certainly would not assume that such an answer could be compelled from the defendant. That is purely testimonial communication on the part of the accused. And no court would allow such compulsion. And yet that's precisely what is being asked of Mr. Menon here. The point, if we look at this court's decision in United States versus Fisher, it said that this court said that the accused cannot be asked to repeat, restate, or affirm the truth of anything contained, in that case, in documents, as to your point, Justice Leeson, that there are certain cases in which the government can prove that there was a foregone conclusion as to the control over the passcode. We can see this in the Third Circuit's decision in Apple Mac Pro computers, where the accused sister had seen the defendant enter the passcode, had seen all of the contents of the hard drive in that case, and could attest not only to his control and possession of the passcode, but also to the contents of the device. And so the issue of whether or not the accused can ever be asked to enter a passcode is not really at issue here, because those, again, are cases in which the device was seized from the person or in which the device was seized in a warranted search.
Can you cite to me a case that's made the distinction that you've made, not on the testimonial production, but on the control versus non-control aspect? And in this case, just to tie, weren't the police looking for non-control type evidence, that they believe that if they could access the phone, there would be evidence that would go to the, not to the control issue, but the actual crime itself?
Well, in the 11th Circuit's case of In re Grand Jury, where it was found that that it would concede control and access and to the files and to the passcode itself for the accused to enter the passcode, and that was in fact a forced decryption case rather than a turning over of the passcode, disclosure of the passcode verbally to the police. And even in that case where a forced decryption was an issue, it was found that would reveal control and access and would disclose that to the government. So
I'm always worried about the rule that we make that's going to, and how it's going to apply in, for instance, evolving technology. I mean, my phone now, if somebody holds it up to my face, it opens up my phone. So that would evidence control. I mean, how does the rule that you're asking us to write in your case, how's that going to play out in this world of advancing technology?
Your Honor, the question that you're asking, going back to Justice Parrish's question as well, the question of biometric data, being able to use biometric data, there's a long-standing precedent in this court going back 100 years to Holt versus United States, and in a long line of cases, Schmerber and Gilbert and all of these things that have to do with blood draws and physical characteristics being displayed, where when the accused is asked to display physical characteristics, that there is not testimonial evidence there. Now that certainly is a complicated issue for this court to tackle. However, that is not the issue we have to tackle today because of the lack of control over this phone that has been described by the government in this case. We don't necessarily need to face that question. However,
but why not? And this is where I'm struggling. If we agree with you on the approach that the control aspect is the distinction, then don't I have to revisit all those biometric cases, because those biometric cases do not make a distinction between control and non-control as determining whether you have a testimonial Fifth Amendment problem. And so you say, well, you don't have to do it, but aren't I calling that entire line of questions, cases, which you just said goes back 100 years, into question because we're now going, based on your theory, creating a new way of cutting these cases. Isn't that right?
In the sense that there are certain physical characteristics that could ever be displayed in order to match against something that was found at the scene. Again, we could look at the same analogy to a gun found at the scene. There are certainly ways in which guns can be searched and seized from individuals and then matched for ballistics purposes to a bullet found at a scene, for example. And so there is plenty of jurisprudence in this court that would suggest that you would in fact not have to revisit those precedents in order to follow the rule that we're asking for here. However, I would like to say in the alternative, if this court were to consider this an act of production and were to try to apply the foregone conclusion doctrine, as some of the lower courts have done in these cases, that the government simply has not met the burden of proving with reasonable particularity the existence, control, and authenticity prongs of the foregone conclusion analysis. And that's because they are asking Mr. Menon to affirm, to restate, repeat, and affirm those very prongs with the questions that they asked. They are asking him to affirm that it's his phone, that he has control over it.
Well, if we adopted that analysis, doesn't that mean that the passcodes could essentially never be a foregone conclusion?
I don't believe that's the case, Your Honor, that there are plenty of instances in which passcodes could be a foregone conclusion, as they were in the Third Circuit's decision of Apple Mac Pro, when you have eyewitness testimony that has not only seen the passcode itself being entered, but has in fact seen the contents of that device.
So you want us to adopt a traditional authentication approach?
In terms of the 902 analysis, may I?
Yes.
In terms of the Federal Rules of Evidence in 902?
Yes.
So the recent additions to 902, subsections 13 and 14 that just went into effect this year, have not been adjudicated for whether or not passcodes would apply in those situations. However, it's certainly possible that such would be the logical effect of self-authentication in the case of electronic processes. Thank you, Your Honor.
Thank you. Representing the United States, Michael Smith. You may proceed whenever you're ready.
Mr. Chief Justice, and may it please the court, Michael Smith for the United States. The only relevant way in which the act of producing the passcode is testimonial is that it communicates, I know the passcode. What the petitioner was being asked to do in this case essentially is to open a door. And that does incriminate him because it shows that he is capable.
But isn't it really the same as asking, is this your phone, or is this a phone that you use when you're asking for the passcode? And if so, does that make a difference?
I don't think so, Your
So
Honor.
the officers would have been able to ask him, and he would not have had a Fifth Amendment right not to answer the question, is this a phone that you use?
Well, I think the question, I think that question would fall into what my friend for the other side referred to as the bucket for purely testimonial. In that case, what would be incriminating the answer to the question is something that in and of itself could then be used by the prosecutor at trial as evidence against the accused, whoever is being asked the question in that scenario. That is different from the act of producing the code, which the only thing that is communicated there is implicit. It is that they know the code. That is the material consideration, as my friend for the other side concedes.
But let's assume there was nothing on the phone that was incriminating at all. Wouldn't the government then have used the fact that he opened the phone as evidence that the phone was his, and therefore cementing the case that he was involved in the bombing?
Well, if there was nothing on the phone connecting the phone to the bombing, Your Honor, is that the question?
Well, I'm saying if there's nothing additionally in the files of the phone, wouldn't the prosecution have used the fact that he was able to open the phone as evidence that the phone was him, and therefore that he was more closely, that it was him that was connected to the bombing?
So surprisingly, as far as we are aware, there's no direct authority on this question in the context of the act of production doctrine. We would think that just as a matter of principles of estoppel, that it would make sense to bar the use of that response, or the use of the fact that he knows the code, because the whole point of the act of production doctrine is that the police already know that the accused knows the passcode. They already have some independent knowledge, at least in terms of the foregone conclusion doctrine, that the code is known to the accused, and they could use that for purposes of proof. So the additional information, in other words, the testimonial, the communicative aspect.
But what evidence do you have that the phone was his?
Well, the material issue, Your Honor, we would submit is not whether the phone is his, it's whether he knows the passcode. The district judge below, Judge Mehta, explained that multiple eyewitnesses testified.
So if I agree with you on that, right, isn't it still material in the case, not on the question of the Fifth Amendment, but the case as to whether the phone was his? And if it is, doesn't that make your case as a prosecution stronger? If that's true, then it seems like there's a testimonial nature to him proving the passcode, because it shows that the phone is more likely his rather than somebody else's.
That may be true not as a question of the Fifth Amendment. That is, we're perfectly willing to concede that. What we are saying is that the relevant analysis here has only to do with the communicative aspect of whether he knows the passcode. Because to go beyond that is to go beyond his act of what he's supposed to be doing, which
But
is
what if he reasonably believes that answering the question or providing the passcode is going to incriminate him? At the time that the request is made, it may not be clear whether or not this evidence is going to be used to establish one thing or the other.
I'm sorry, I'm not sure I understand your question, Your Honor.
Well, in terms of the invocation of the Fifth Amendment privilege,
Yes,
here, the plaintiff invoked his Fifth Amendment right.
that's right.
It ends up being used against him at trial because the video is shown. But there is an aspect with invocation of the privilege of whether or not the person invoking the privilege reasonably believes that responding is going to be incriminating. Why didn't Mr. Menon reasonably believe that providing the passcode would be incriminating? And isn't that enough, even if the way the evidence is actually used turns out to be more like an act of production?
Well, we don't think so. It seems to be reasonably clear from the record that Mr. Menon did believe that it would be incriminating. It's likely that it would have been. The relevant question is whether the act of producing it gives any kind of prosecutorial advantage, in the sense that it gives them, the act itself gives the prosecution any new information. And here it did not. As the district judge in this case described, there were multiple eyewitnesses that testified that they had seen Mr. Menon using the phone, and at least one eyewitness had testified that she had seen Mr. Menon unlocking the phone. And that can be found on the record at page 35 and 36.
Mr. Adams, how does the government meet the authenticity requirement of the foregone conclusion?
So our position is that in terms of the Fisher framework, the three prongs that were being suggested by the Fisher framework are not an exhaustive or a conclusive list. The question when it comes to the act of production is there something additional being communicated beyond just the content or the substance of whatever is being produced? And here, what is being communicated is, I know the phone passcode, which you could consider to be both the existence of the code, which they already know, and the fact that Mr. Menon has possession of the code, which they already know. The authenticity question doesn't quite fit in the modern context of the cell phone itself, because there's a sense in which the very fact that the passcode exists and that the person who knows it is aware of what that passcode is and that it will open the phone means that it is authentic. It would be very strange for Mr. Menon to be walking around with false passcodes in his head. So there's a sense in which it is self-authenticating.
You're really asking us to do that. You're framing it differently, but you're asking us to adopt a self-authentication for passcodes.
We just don't think that the act of producing a passcode in and of itself is capable of conveying some sort of a fact about authenticity. Either they know the passcode and it is authentic just automatically, or they don't know the passcode, in which case the question of authenticity just does not come into the analysis. What matters here is whether the phone, I just want to add on to the fact that in the record, there is at least, in addition to the testimony of the multiple eyewitnesses, there are at least two other significant pieces of evidence that show that the government did know that Mr. Menon knew the passcode. First, the phone was registered to an organization of which Mr. Menon was second in command. And second, his fingerprints were found on the phone. So the issue
but doesn't that cuts against you? I mean, it can also cut against you, can it? I mean, if you have all these piles of evidence that it was his phone, then why do you need to force him to reveal the passcode?
Well, not for any sort of a testimonial purpose, but beyond that line, beyond the door being opened, which is, of course, the only question that is before this court, there is an instrumental interest that the police have in getting into the contents of the phone and affecting a search and affecting seizures of anything that they find.
Get a warrant.
That is a Fourth Amendment question and not one that has been raised by the petitioner. There's nothing in the record to suggest that if Mr. Menon had, in fact, turned over the passcode, that the police somehow didn't have a warrant or had some sort of a deficient warrant. I think the implication in the record is that they did, but the bar is raised not.
If you had no evidence at all of ownership or control, which is what I understand the petitioner argument to be, do you then concede that this would have testimonial implications by virtue of knowing the passcode and showing it to you would be evidence that in fact there is ownership and control?
Well, it's hard to imagine a scenario, Your Honor, in which Mr. Menon, in which the police had no information about Mr. Menon's ownership or control, but somehow also knew from some independent source that Mr. Menon knew the passcode. So I would say, with the exception of some sort of scenario where that could be imagined, where they did know that he knew the passcode, but somehow also simultaneously had no knowledge of his ownership or control.
I'm confused on the argument there, and maybe I'm just missing. Why does the police know? I understand why it goes to the foregone, but why does it have anything to do with the testimonial nature of the disclosure? So why does it matter for Fifth Amendment purposes that the police knows that he knows the passcode for whatever reason, if they don't have any other evidence of control and ownership?
Because of the foregone conclusion doctrine, quite simply put. He's only protected by the Fifth Amendment against self-incriminating testimony, something that can be used against him.
Well, that's why I'm asking you. If you've got no other evidence of ownership and control, by definition, him either putting his finger to open up the phone or giving you the passcode becomes the evidence that you have of his ownership, and that's testimonial. You never get to foregone conclusion, right?
I think that's precisely correct, but it's counterfactual with respect to the record here, because they do have a substantial amount of evidence of his ownership and of his control. That's what establishes their knowledge of the fact that he knows what the passcode is. That's why the foregone conclusion doctrine applies.
So what's the standard then for determining whether you have enough evidence of that the additional evidence of control and ownership is no longer material and relevant?
So my friend for the other side did mention this towards the end of his argument. He mentioned, he attacked the idea that what the detectives knew, they did not know to a reasonable particularity. And that is the term that has been used in the context of cases in which the government is trying to compel documents. By definition, we think that can't be true. That standard comes from cases like Fisher and Hubbell. And in that context, there is an obvious difference between give us all of the documents that you have that show that there was a meeting on May 18th and give us your calendar, which records the May 18th meeting. In the former, the government doesn't know if there are any responsive documents. They're hoping to find some. In the latter, the fact that they are able to state with reasonable particularity that there is a calendar and that's what they want, that specificity suggests that they know from some independent source that the calendar does exist. But that distinction in the context of the passcode breaks down. There is no meaningful difference between saying, give us all of the means that you are aware of that will open this phone and give us the passcode. It's part of the nature of the way that these phones work. If the detective picks up the phone and it prompts him to enter a passcode, then they know that a passcode does exist. And so when they request it, they can always say, very specifically, with reasonable particularity, what we're looking for here is the code.
Mr. Smyth, let me ask you, can a passcode itself theoretically be self-incriminating? Does that possibility exist? The sequence of numbers and letters?
We think it does, Your Honor. We think it is
Could be
entirely
self-incriminating.
possible. Yes, it could be. So if the analysis had nothing to do with the act of production, if it were a purely testimonial analysis, which in this case it is not, then it's of course possible to imagine a scenario in which there was a passcode or passphrase, the content of which is incriminating, not the act of producing, but the content of which. There's nothing in the record to suggest that this was the case. But if Mr. Menon had a passphrase rather than a passcode, and that passphrase was, "I am a terrorist," that, of course, would be incriminating.
What if the passcode is his birthday?
Well, that wouldn't convey any information that would...
It would suggest that it wasn't just that he had the passcode, but in fact that he was the person who created the passcode and used his birthday, which is more incriminating than the alternative option.
Right,
correct?
and it's not the content there of the passcode that is incriminating. It is the implied, the implicit, the tacit communicative act, which is precisely the province of the act of production doctrine. So we think what would happen in that case, if the content of it was something that were incriminating.
I'm sorry, are you agreeing or disagreeing that if the passcode were his birth date, that would be more incriminating than if it were a random sequence of numbers?
That is absolutely true. It's certainly true that the content of a passcode can be incriminating. What would have happened, and I don't take it that is the petitioner's concern, what would have happened in the court below if that were the concern, if it were the concern that the content of the passcode were incriminating, is that Assistant United States Attorney Smyth, not me, but the government counsel for the trial below, would simply have amended the motion to compel so that Mr. Menon was not being asked to state the code and therefore divulge the contents of his mind, but simply that he enter the code. and therefore unlock the phone. Again, what the detectives are interested in is that the door be opened. They don't particularly care how the door is opened, and that would be fine. I would just like to address before my time expires that if the reasonable particularity standard is not the standard, and we don't think that that means that the government gets a free pass, we think that there does have to be a standard, then the question, of course, becomes, what is the standard? It can't be based on specificity. We're aware of only 2 cases that address this head on. They're both recent, naturally. One comes from the district court in Colorado in 2012. That's the United States versus Ricosu. And there, the court adopted a preponderance of the evidence standard. But notably, this is with respect to how can we be certain what the government knows? But notably, they didn't justify the choice. And then earlier this year in the Northern District of California, Judge Charles Breyer adopted a clear and convincing evidence standard. That opinion did offer reasoning based on the policy, and this is a direct quote, of the law's jealous protection of the privilege against self-incrimination.
So why did you guys enter the information? Why did you use it as evidence to begin with? You have all this other evidence. You say it's not particularly useful for you other than getting the open door. So why was it useful for you at trial?
Well, without speculating too much about about AUSA Smyth's strategy at the trial, I would suspect that it's simply a question of weight. That if you have 3 witnesses saying something, that's better than having 1, and that if you have 3 witnesses and a video that would seem to suggest the same thing, that helps you have a better case.
But given that your argument is that you have all this other evidence, isn't it just better us to be more protective on the Fifth Amendment and say you just can't use it in these sort of circumstances?
We just don't think that implicates the Fifth Amendment. And if there are no further questions, we would respectfully ask that this court affirm the decision below.
Thank you, Mr. Smyth.
Thank you.
Mr. Adams, rebuttal.
Thank you, Your Honor. Is this your phone? What is the passcode to this phone? Those are the 2 questions that were asked of Mr. Menon by the police. We see that in the video that's linked on page 23 of the record in footnote 3, and we even see it in Detective Vasquez's testimony found at pages 69 and 70 of the record. Those were the questions they asked, and as you were concerned with, Justice Wood, that's precisely what the government was seeking to affirm, was seeking to have Mr. Menon repeat, restate, or affirm in his testimony. And the assertion from the government's counsel that they were not going to use this evidence for any other purpose is belied by the fact that they did, in fact, show the video of his silence at trial to use against him. Now, they have stipulated that if this court is to find that there is a testimonial aspect to this communication, that would be a Griffin-Doyle error in this case. And so we're not here arguing over that point. But another point that we're not here arguing over is whether or not the government is seeking forced decryption or seeking Mr. Menon to turn over the passcode. And that's crucial for another point you raised, Justice Wood, that if they were seeking forced decryption, then that would have been what the November 30th, 2017 motion to compel asked for, but it is not. It asked Mr. Menon to reveal the passcode to the government. And to the point of whether or not the passcode could be Mr. Menon's birthday or some other identifying information, the government, it's not possible for them to know in advance whether or not that is the case. And so for them to say, if it was his birthday, it would be more incriminating, well, how would they know ahead of time? It's impossible.
Since we have to be concerned about, at the Supreme Court level, the effect on all 50 states and all cases in the future, how about this hypothetical? Instead of having him disclose his passcode to the government, just compel him to form a new passcode, 12345, and open the cell phone.
Well,
that particular passcode does not reveal anything confidential or incriminating or.
That's true that passcode itself would not have a testimonial value, except that as the 11th Circuit found in Enri Grand Jury, the fact of disclosing or forcibly entering the passcode would in fact disclose the control and access that the defendant had. And so in a case such as this, on these narrow facts under which the control and access to the phone is an issue, this court should establish a rule that the passcode cannot be compelled from the accused.
Well, I think what's troubling here, and it's been raised a couple of times, is how to reconcile the rule that you're advocating for with respect to these passcodes with the prior case law involving things like fingerprints and other physical attributes. And one thing that strikes me is as different between fingerprints and your retinas and other things that are used as security devices now is that those things, they are what they are. The person doesn't have control of what their fingerprints are. Whereas with passcodes, in most cases, the person who owns the device is the person who decides what the passcode is. In those circumstances, isn't it a whole lot more incriminating if somebody's fingerprint matches up with the security device, or if I hold up to the phone to their face, it opens up, than if somebody simply has the passcode, because maybe they share it with 10 other people or they just happen to know it. Whereas if I hold the phone up to your face and it opens, it's pretty much yours. How do you reconcile those two things?
You may answer, Mr. Adams.
Your Honor, I think that this question would be guided by this court's decision from earlier this year in another realm, in the Fourth Amendment realm, in Carpenter, where the court said that you shouldn't mechanically apply old tests to new technologies. And in that case, there was the question of whether or not the third-party doctrine should continue to apply in the Fourth Amendment context. And would a case come before this court that was dealing with biometric features to unlock a phone? That would certainly be a very difficult question to encounter. However, in this case, we are dealing with this narrow set of facts over which the control and access are still an issue. And if the court has no further questions, thank you.
Counsel, we want to thank you for your very good presentations this evening. The court is going to be in recess while we consider the arguments that have been presented.
All rise.
All right, so while the judges are deliberating, we will have a brief intermission outside. There will be 2 locations where we will be serving drinks, and there should be appetizers out there. So.
Michael, there's a man waiting for you right here.
Yeah.
There's a man waiting. Hi, Professor. I know, I talked to him, and I said I appreciate that.
Really good. Really good.
Professor, thank you.
And congratulations to you on winning the Golden Employee Share. Very impressive. I was blown away. Gravity.
Right, exactly. I know it's like really classy.
Thank you for judging.
Here I am. Hey, I would love to get some coaching. Just in general, like, I'd love to sit down and get because like I really do. I need to.
Wow, do you think you're really going to be doing a college? I was going to be expecting you're going to do a trial.
I think I'm going to do it. I want to do it. I don't know what I'm going to do next. But ultimately, I think
you don't have to deal with witnesses.
exactly. I was actually just having a conversation with a friend of mine who's a public defender in New York, who he was talking about this case he just lost. He was like, injury. No, it's counsel can do direct examinations. All the guys that work with always picking up their own. Exactly. And I'd rather do that. Yeah, I don't know if it's as crossing a witness. I remember we did a thing at college last year over spring break where he came back with me. And we did like a mock class with him where he taught cross-examination through like undergrads just in and out. And he was like, and it was remarkable. He turned it into with Judge Brown. Yeah, absolutely. And if there's like an extra doing that shit, that's a case. Just a because they did it last night. Last night. I think like Taylor and some of these others for the third.
Yeah, I think that's the trial at Flash.
Oh, okay.
It's like there's a 2L contest. I think it's early spring, which is like it's like this, but just for trial. And no one does it because like
right. I'm into it.
Thank you all so much for coming back in so quickly. And if I could ask everyone to go ahead and have a seat, please. Really quickly, while I have a lot of law students in one room, I would like to remind you all that this is only the first competition that we host. That in the spring, we host our second competition, the internal trial competition. This involves teams of 2 preparing a trial based on a pre-existing record, which is similar to what you did for the moot court competition. The competition takes place the 19th, 20th, 26th, and 27th of January, and registration will be open soon. So we hope to see you all competing in that next semester as well. Thank you.
Good evening. My name is Jennifer Smyth. I was one of the executive judge coordinators for the competition this year, and we're going to get ready to bring our panel of judges back and introduce them. All right, so serving on our Supreme Court this evening, starting on the far side, we had Judge Joseph Leeson Jr. for the United States District Court of the Eastern District of Pennsylvania, Judge Beverly Baldwin Martin of the United States Court of Appeals for the 11th Circuit. And on this side over here, we had Judge Andrea Wood of the United States District Court for the Northern District of Illinois, and Austin Parrish, the Dean of Maurer School of Law, and James H. Rudy Professor of Law. And serving as our Chief Justice tonight, we had Justice Christopher Goff of the Indiana Supreme Court. So would you please thank our judges. And before we announce this year's champions, I just wanted to thank everyone who judged the competition this year. We had more than 140 volunteers judge 52 hours of arguments. And this included alumni, sitting attorneys, sitting judges and attorneys, faculty, and many 3L students. So if you judged the competition this year and you're sitting in the room, could you please stand and be recognized? And with that, I will turn it over to Chief Justice Goff.
Well, thank you. And would you join me in just giving our oralists one final round of applause? They were just outstanding. One of the things I just want to preview this with is I have a colleague named Steve David on the Indiana Supreme Court, and whenever I have to make a decision or a decision is being made about me, he reminds me that decisions like this are somewhat subjective. And so if you win, take it with a grain of salt. But if you lose, you will fight another day. And you are truly in the arena with champions. I think 6 rounds leading up to this. So we had a very difficult decision, and we had a lengthy discussion. And I can tell you all that this was very close. But it is the consensus of my colleagues and myself that our top 2 oralists this evening are Ben Adams and Michael Smyth. And truly, all of you gentlemen, Mr. Appel, Mr. Bauer, you did an outstanding job, and you should be tremendously proud of the work that you've done. I would, at this time, just want to call on my colleagues to make some brief comments, and I'm going to first call on Judge Joseph Leeson.
Thank you. What we saw tonight was truly excellent work. I've been on the bench for several years now, and I've heard many arguments by many lawyers from New York and Washington and Chicago and Los Angeles. And truly, you were better than most of the lawyers I've seen. Very few lawyers that I've seen have done a better job than you did. And I'm going to tell you why. Is all of you spoke with confidence. And one of the most important things about being an advocate is to speak in behalf of your client with a belief in what the client is advocating, what the client is standing for. And all of you spoke with confidence. And that's a key ingredient of good advocacy. You couldn't be easily ruffled. You were asked some tough questions by my colleagues, and no one was thrown off their game. You all had answers. Some of you had tougher situations. Some of you had not so easy situations to deal with. Some of you had weaker hands on the side you were dealt with, but you couldn't be thrown off your game, and you really came back with good responses. You were all extremely well prepared. It was very impressive. One of the things I sometimes see in the cases that I have, I'll ask the lawyers, I'll say, well, what about XYZ in the record? And they'll say, oh, well, can I check that for a moment? That doesn't fly. All of you knew the record. You couldn't be caught off balance. On more practical things, you enunciated well, you spoke clearly, you made good eye contact. And that's very good in terms of convincing a judge that, hey, I know what I'm talking about. What I'm talking about is important, it's right, it's good, and I want you to hear it, and I want you to see it through my eyes, because the eyes lead you to the heart, and the heart leads you to the brain. So it's always good to make good eye contact with the judges. And so overall, I have nothing but compliments. In all courtroom situations, even in a moot court, there are winners and there are people who do not win. But tonight, But tonight, even though we have 2 winners and 2 who didn't win, all 4 of you are winners in my book. And because you're going to make great lawyers, and your dean and your professors have a lot to be proud of. So I thank you for the honor of giving me the chance to be here tonight to judge this moot court. Good job.
This is the first time I've ever done this where they announce the winners and then let us drone on. So I'll try to be short. Thank you for inviting me. It's such a lovely school. Everyone here has been wonderful, and the program seems so well run. I'm so impressed with the advocates. This is what I do. I sit behind a bench and ask questions of people standing at a podium. Any of the 4 of you could appear in the 11th Circuit and distinguish yourself tomorrow. I mean, it's very impressive. And I hope that you will pursue an appellate practice. I thought you were responsive to the questions. You were all familiar with the record. For me, the thing that I see that's hardest for advocates to do is to professionally and politely, but assuredly disagree with a judge that's trying to sell their position in the case. And I thought y'all did that very well. I think that's really the sign of a great advocate. And boy, you've got a lot of years ahead of you to do it. So I wish you well, and I'm very impressed. Congratulations.
Well, I'll try to be brief as well, because I agree with what my colleagues have already said. I thought all 4 of you did a tremendous job. You were incredibly well prepared, very poised. Your presentation style struck just the right note of professionalism without being stiff, engaging, without being over the top. I think that's something that lawyers who have been practicing for many years struggle with. One thing I was particularly impressed by in all of your presentations was that you all listened to our questions and to each other's arguments. I think sometimes in these sorts of formats, you become so immersed in your own position and you're preparing so hard, particularly if you don't know until a couple of days before which side you're going to be arguing. So then you're cramming your argument and your points that you want to make. When you actually get to the competition, it's tempting to start responding to questions in your mind before you've actually listened to and processed what the question is. And so you might end up answering a question that wasn't what was actually being asked, but the one that you were anticipating, or maybe the one that you were hoping would be asked. And I've done several moot courts. That happens a lot. I didn't feel that here at all. I felt that all 4 of you did a really wonderful job of listening and then responding to each other's arguments, when you had the opportunity to do so through rebuttal. So I thought that was excellent. And I won't spend much more time repeating what my other colleagues will say, other than thank you for the opportunity to be here and to get to watch you do what you did so well. Congratulations on a wonderful competition.
I'll make some very quick comments. I wanted to congratulate the Moot Court Board. I thought this was an exceptionally well-balanced problem that really had some interesting issues. So maybe another round of applause for all the judges. Maybe a little tougher than some of the other judges. I'm like, damn right, you better be better than those LA, New York, DC. This is Indiana. I thought it was exceptionally well done. I always think the difference between the really high quality advocate who was talking about responding to the specific questions asked and showing that you're engaged in the discussion rather than just having a pre-scripted. And I thought all of you did that very, very well. And great boys, great forensic approach. So I thought it was extremely nicely done. The one thing that I thought would some people sometimes did really well, and then the same people didn't do so well as other times, is thinking about where you can concede. And everybody made concessions in very good places. And there was a couple of times where I thought you could say, well, I probably could concede that and you were losing the bench, but that's very, very minor. I thought it was exceptional. Really proud to be your dean tonight. And thanks so much for inviting me today. It means a lot to me.
I wanted to close because as the newest member of the Indiana Supreme Court, I always have to speak first. And I just want to take just a quick moment to thank Dean Parrish for your hospitality. I want to thank Inga Vanderkruis for taking such good care of all of the judges, and to once again congratulate your board. These materials were just outstanding. Did you guys see that movie, that film? That was incredible. And then the materials that we had in anticipation of this, I was trying to read those last night, and I had my two granddaughters that were screaming at the same time. And it was a lot to take in. I went and shut my door. I want to approach this real quickly, but I want to do it just a little bit differently than my colleagues. I don't want to talk about tonight so much as I want to talk about the future, and the future of you four in particular. But I imagine that the competitions leading up to this, many of them were very close calls, and you probably have some very, very strong advocates who didn't quite make the cut for tonight. And to all of you, I just want to suggest that you have a gift. Our society is going to be a kind, civilized society or not, depending largely on the arguments that folks like you make. And I want you to own that responsibility. When you leave this place, you're going to be ready to make a big impact on the world and an impact for good. And I want you to think about that sometimes when you're at a study break. How are you gonna do that? How are you gonna make the world a better place? You're just beginning, and you're all four off to such a tremendous start. This has been really one of the highlights of my service on the court so far. So thank you for the opportunity to judge your competition tonight, gentlemen. Congratulations.
Thank you all so much for coming.